Hi, everyone. Thank you for coming. We're going to give it a few minutes for everybody to join. We're going to give it a few minutes, guys, okay? Because there's a lot of people who are trying to join this particular conversation because of how important this conversation is going to be. So I just want to make sure that everybody has the ability to get on this particular webinar. But if you guys have any questions, I just want to make you understand that when you put stuff on the chat, it may be public. So make sure that whatever it is that you say, if it's going to be confidential or something that you don't necessarily want the public to know about, please do not put it in the chat. Just general disclaimer, if you're trying to kind of have a specific question for me, I will do my best to answer. Just remember that this is not a conversation that establishes an attorney-client relationship between us. And at the end of the day, I can only give general legal advice. And there might be more to your background and your circumstances that we have to deliberate and determine that could be better served in a consultation. So I'm going to give it a few minutes, guys. Please be sure if you add your questions, the earlier the better, so that way I can scroll through them towards the end when we have the Q&A. Okay? I think we're going to be set to start in about a minute or two. Hi, everyone. Thank you for joining. We're going to give it a few more minutes, all right? And I know that there's a lot of, not even content to go through, but a lot of the guidances that are out there. There's so many different things that have happened even since the proclamation was first announced on Friday. I'm going to tell you that right now we're going to go through that entire timeline, kind of parse through a lot of the materials and see kind of where we're at today. There's a lot of rumors, there's a lot of discussions, there's a lot of stuff on social media. And what's so fascinating is how 2025 is so different, right? Even compared to COVID, like the fact that we're relying on statements that are made on X / Twitter, like to make these judgment calls are kind of insane at the moment. But, you know, as insightful as they can be, we try to be as clear as possible. All right. Okay, so I think we're ready to get started. Thank you so much for joining us on this conversation. I know many of you are a little bit distressed. Many of you are trying to seek as many answers as possible. So I am going to do my best to give you those answers. So the topic of today's webinar and today's conversation is this new $100,000 H-1B fee. We're going to talk about the timeline of events really leading up to this particular moment. So let's start first with who am I? I'm going to be very quick about this. My name is Nicole Ganara. I am the principal immigration attorney here at Manifest Law. I have about 7 years of experience in immigration and have held leadership positions at prestigious law firms. My focus areas are generally on talent visas like EB-1As and O-1s, in addition to business immigration related cases. I have helped multinational companies and emerging companies establish their corporate immigration programs, whether it's designing those talent pipelines or maintaining those talent pipelines, right? So when you're asking who do you know that knows a lot about H-1Bs, Es, Ls, O's, and the like, that would be me. And just as a reminder, Manifest Law is a tech-enabled, tech-forward firm. A lot of our work has to do with trying to change what the immigration industry is going to look like in the next few years and how legal practice generally should be when you are working with a lawyer. So hopefully we can have those conversations. And if you want to reach out to us, we'll give you some contact information towards the end. And yeah, I'm very familiar with TN visa. So anything that requires like a work visa, I do know a lot about. Okay, so moving forward. So what is the agenda of today's conversation? Now, I want to make sure that all of us know what I'm going to be talking about, so you feel whether or not you should be staying here for this conversation. So number one is we're going to go through the timeline of events, because I think the timeline is super important. The reason why the timeline is important is because so many things happen and all of those things said slightly different things. So I think us parsing it out together is going to be really, really helpful for every single one of you. The second thing that we're also going to talk about is the attorney perspective. What is it that I think? Like, how am I interpreting all of these things, right? How does this impact you? I really think that that could be helpful. Number three is talking about H-1B visa alternatives, because the reality is that many of you may be sitting here and feeling very vulnerable because it has really impacted and shaken your lives maybe as quickly as overnight and over this weekend. So what are my other options is a real question that is being asked. Then we're going to talk about some next steps, like what are some approaches that you can be taking and what you should be immediately thinking about. And then, of course, towards the end, we'll be reserving some time for a Q&A. So please be sure to add your questions throughout the chat. I will try to answer some of them in real time as we go through it if it makes sense. But for the most part, I will be following this very careful agenda. So let's talk about the timeline of events, right? This is kind of like the general timeline that is involved. I see that we've kind of organized it from left to right. So let's start with September 19th. Trump announced that there was a $100K H-1B fee during the live stream, which directs DHS to draft the rules. Essentially, this live stream, there was a lot of questions, there was a lot of answers that were provided, and those questions and answers that were provided live actually sourced a lot of sense of confusion. And the reason why it created a lot of sense of confusion is because there were statements like, is this an annual fee? Is this going to be something that is charged all up front? And there was a lot of yeses and there was a lot of no's. And we didn't really see until towards the end of that day the full written proclamation. So that was like the next thing that occurred. So just to kind of walk through very quickly, because this is just a general timeline, when it came to the initial announcement, they basically said statements, $100,000 fee applies for the first time and for renewing H-1B applicants, that the executive action directed DHS and the Department of Labor to draft new guidance and rules. There was a lot of immediate uncertainty about one-time versus annual fee. And then analysts said that, hey, there was probably going to be a major tech industry impact expected. So then what I was talking about was the proclamation release. So on or about 9:30 p.m., we finally got the written document, and the publication or the proclamation specifically says restriction on entry of certain non-immigrant workers. Key emphasis on entry, right? So essentially what this proclamation stated was that effective September 21st of 2025 at 12:01 a.m. EDT, right, Eastern Daylight Time, that entry was restricted unless an employer could prove that they paid this $100K, that DHS was barred from approving new H-1B petitions without the fee, and that the Department of State was to restrict related B visa issuance, which was a very interesting part of this proclamation release. So this is what incited probably the most amount of panic or like kind of confusion, was because, wait a second, so it does seem to be a blanket application, and further to that, it's going to be effective on Sunday early in the morning. So that's where you saw on social media a lot of people trying to get off the plane, people trying to fly right back, maybe getting a boat or something, anything to come back into the country before the 21st of 2025 at 12:01 a.m. Thereafter, because of all of this confusion, literally the day after, we started to see these White House related clarifications. It started first with a lot of reporters making statements based on conversations with White House officials and the like. But we finally got our first, let's call it, publication when Caroline Leavitt, who is the press secretary for the President of the United States, published on X this particular statement that's on the screen. She stated that the fee is not an annual fee. It's a one-time fee that applies only to the petition. So petition means that filing, right? And that it only applies to new H-1B visas and not renewals at this case. More specifically, I would say that they said that those who already hold H-1B visas and are currently outside of the country right now are not going to be charged $100,000 to re-enter, which is a little bit different than what the proclamation says. And then number three is that it's applicable to only new visas, not renewals and not current visa holders, was a very interesting point to make, especially given the last sentence where it goes, it will first apply in the next upcoming lottery cycle. So for many practitioners that were reviewing this particular tweet, our first kind of thought process is, well, this is very different from the proclamation. Is it possible that this isn't going to start until March of 2026? So everybody before then is in the clear, right? And then the rapid response team, which is a team that seems to publish things on behalf of the President of the United States as well, also kind of said similar things to what Caroline Levitt said. You can see it on the screen. But generally speaking, both statements did not really reflect what the proclamation said. And there was a lot of legal ambiguity that really remained. Like, what does this all really mean, right? What does it mean for me, who is somebody who maybe has a pending application? What about a renewal in the country, right? What if it's an extension or a change of employer? Those questions were still not really answered. And then thereafter, a little bit, after a lot of those publications, we got the USCIS and CBP guidance. So they published policy memorandums. And these policy memorandums actually clarified to some degree who was affected. But there were still some major differences, and I will try to emphasize what these differences are. So what these clarifications were focused on the fact that petitions that were filed before the September 21st deadline were not subject to the fee. So that was good to hear for people who had pending applications, and that current approved petitions and valid H-1B visas were unaffected. However, what was still unclear was, is it a one-time petition, a one-time fee? Is it a recurring fee every time you file a new employment application? Is it that the application to the fee extends even to extensions, transfers, or changes of status that were in the US? But the one thing I will say that was confirmed by USCIS and CBP was that current H-1B holders may travel internationally without this fee, barring any further guidance. The one thing that I really also wanted to emphasize that this USCIS and CBP guidance kind of deferred even from the press secretary's statement was, when was this all effectuated? Remember that in the previous tweet, it says that it will first apply in next year's lottery for the fiscal year of 2027. But the statement that was made by USCIS and CBP emphasized the September 21st, 2025, 12:01 a.m. EDT date. And also on top of that, they didn't express how mechanically we would pay this $100,000 fee. So I'm definitely very curious about what that rollout will look like in the following days. So that leads me to the fifth item of update, which is that USCIS actually updated on their website an FAQ post, which tried its best to further clarify the statements that they made on the memorandum. The first thing that they said is that the $100,000 fee applies broadly. It covers any new H-1B petition filed after September 21st of 2025, and it's not limited to just the 2026 lottery filings. Again, a little bit distinguishable from what was stated on the DHS press secretary's announcement. The other thing that was conflicting about this particular statement was that CBP was the one that said the fee applies only to petitions that were filed from outside the United States. However, the USCIS statement on the FAQ says that the only carve out is for renewals and also to be determined exemptions that were made by the Secretary of Homeland Security. So there's a lot of uncertainty around definitions. It's unclear if transfers or changes of status count as renewals. And the reason why we say, like, does it actually count as a renewal is because when you get a change of status file or you file for a change of employer as a transfer, you usually ask for more time. It's usually filed as an extension. So is that a renewal? Does that mean that you're exempted from the $100,000 fee? It's unclear. The conservative assumption is that the fee applies to most filings, except for the straightforward same employer extension. So if you're continuing to work for the same employer and you're extending it, in all likelihood, that should count as a renewal, but everything else is definitely still up in the air because this definition of renewal is not clear, at least to us here at Manifest and for myself as a practitioner. So where does this leave us as of today, right? As of right now? Technically, the executive action is effective. Like the 12:01 a.m. EDT, that has been put in place. DHS and USCIS has been tasked with the implementation, but the guidances and everything that we just talked about leaves several really important open questions. Renewals. What about change of employer or change of status? What if you're not traveling at all? Will the fee apply to someone filing after September 21st of 2025 and who goes for stamping outside of the US and tries to enter? That is still a question that is up in the air, that is confusing, right? The next set of questions that we've been seeing is, what is the scope of the national interest exemptions? The reality is that the actual proclamation itself provided these carve-outs, where I think it's section 1, item 3, where it said the Secretary of Homeland Security can say that certain industries or certain companies can be exempted from this $100,000 fee. But that exemption, it's not clear. Is it a critical infrastructure industry? Is it going to be similar to the NIE? What if it's for doctors? There was a Reuters report that was published that basically said that doctors are planned to be exempted from this, but that is still unclear and there is no official confirmation. But my general advice when I'm seeing all of this happen is to avoid non-essential international travel until all of this is clarified, and also to be prepared for alternatives. What if you can no longer rely on the H-1B? What if you are truly one that is impacted by the $100,000 fee? What are the things that you can do to best protect yourself and mitigate those risks and remain or be in the United States? As an attorney, as somebody who's been living and breathing this practice for a while, a lot of my thinking, especially when I'm looking at the bigger picture, is as follows, right? Which is that the administration is framing the H-1B as an economic and national security issue. Take a look at the statements that was made, especially on the live stream. They felt that the H-1B was creating a scenario that didn't encourage or incentivize domestic STEM training. I think the government was really understanding or really emphasizing that they understand at this moment that domestically we have a leaky STEM pipeline, that there isn't enough workers here in the United States that actually know or can do the STEM, so we need to incentivize a way to provide that training. And they also were mentioning statements like restricting the program to only the most extraordinary of talent or the top of talent. And we're going to get back to that comment later on because I think it's also important to highlight. I will tell you that businesses and individuals, their responses are to immediately explore other alternatives. Are there O1s, EB1s, EB290Ws, J1s, E3s, and TNs and the like, and to prepare contingency plans for workability. So for H-1B visa alternatives, this is where we can help. There's a few different categories that we're going to be looking at. J1 specialist and research scholar programs, O1 extraordinary ability visas. Maybe if you immediately qualify an EB1 extraordinary ability green card or an EB2 national interest waiver green card. Alternatively, we can also be talking about country-specific visas that you can switch to, right? So for the J1 Specialist and Research Scholar program, what I want to emphasize very quickly is that these are underutilized programs. So a lot of you may be coming onto the chat saying that I thought these are only for people who are working at universities and colleges. I thought that there was a foreign residency requirement that means that I have to go home for at least 2 years before you come back. So I'm going to help clarify some of those points. A J1 specialist is someone who is an expert with specialized knowledge or proven skills that's coming to share those skills with a U.S. entity of some format. Is it that you're developing a new program, right? A new computer program? Are you somebody who's an architect that's going to be providing new drafts or new blueprints to the U.S. organization? Yes, the maximum is technically 1 year, but you can garner more years by exiting and returning, by basically asking for more 1-year programs. If there is a focus on training and knowledge sharing and cultural and professional exchange, but those are all a lot of structures that can be put into place. Maybe more compelling to all of you are the J1 Research Scholar programs. Again, there's a big misunderstanding within the community that research scholars are only for universities or colleges, people who are academics that are serving laboratories of some format, but that is not the case. Research scholar programs can also be for private companies, and you as an individual can also pay for it. For researchers and professionals, essentially you can get up to 5 years of a work visa for that particular employer. And spouses can work on J2s. What you need to be able to prove is that your work involves research and that there are collaborative professional projects that require you to consult and conduct that research. The reality is that if you're doing something innovative, let's say you're an engineer helping design the brand new latest and greatest of windmills or wind technology, that is something that a J1 Research Scholar program can do. What if you're coding something related to new concepts of digital banking infrastructure? We're living in the day and age where, especially with where AI is going, and maybe the next era after artificial intelligence, like quantum computing is going, that there's a lot of great arguments for you to say, I am pushing the next and greatest and innovative programs and talent here. J1 Research Scholar program could be the one for you. For both, for those of you questioning whether there's a 2-year foreign residency requirement or home residency requirement, it only applies if it's triggered. So take a look at something known as the country skills list. Guys, India is not on that list. That list has been significantly limited towards the end of last year. Then we're going to talk about the O1 Extraordinary Ability Visas. We're taking a look at the qualification criteria that is listed here. I know that many of you may be familiar with it, but you need to just show that you meet at least 3 listed criteria and that it's valid for up to 3 years once it's been approved, and it's renewable. If many of you are questioning, how do I qualify for O1 and how do I get there? The earlier that you plan for it and the earlier that you invest your time, the better it is going to be for you. This is the time for you to start approaching your companies to see how they can support you. And maybe now it's the time that they're most incentivized to consider these alternative pathways to keep you here in the United States, getting them to support you, whether it's financially or physically, by putting you in front of those press opportunities or putting you into the public sphere through conferences and the like. This is one way that you can really push yourself towards a direction that doesn't rely on the H-1B. And many of you may be concerned, like, what if the O1 is too difficult to get? I want you guys to take a look at the approval rates. Statistically speaking, O1s are still heavily being approved. So please don't sell yourself short. You might not know if you've actually qualified already, because some of these qualifications or some of these criteria are much more flexible than you think. Take, for example, the authorship of scholarly articles. A lot of you may think it's just for traditional research articles, but it actually can work for non-academic contexts. If you've written a very well-written paper or article and it gets published in an article or place that is for other industry experts to review, and there's an editorial process involved, it could count as an authorship of a scholarly article, even if it's not in a traditional research journal and it was in a media format that is alternative to that research journal. We've definitely helped regular people get O1As. Like, this is a sample profile here, right? We have somebody who has done software engineering, cloud computing, and cybersecurity. They were born in India, and the petition highlighted that the beneficiaries' pioneering contributions were in software engineering and the like. We emphasized their critical leadership roles and technical innovations, and also their advanced financial technology, their advancements in financial technology and automotive sectors. So I will tell you that Manifest does have an opportunity matching program. So there are ways that we can really help you get yourself in the best position for an O1 to make sense. You also have the EB1 Extraordinary Ability Green Card, which has substantially similar requirements, but they're slightly different. So don't, again, sell yourself short when it comes to qualifying for some of these categories. The EB1A can be most fruitful for you if you already have a priority date set in place, but the sooner that you have an application filed and you can set your own priority date, perhaps if you don't have one, the better it is. I usually treat EB1A as kind of like a roller coaster ride, getting a fast pass, right? The earlier you get that fast pass ticket, the earlier the clock is going to get to your turn. But taking a look at some of these qualifications, you can build up towards it, and it's probably going to be better for you than just solely relying on your time on the H-1B. So this is also a sample profile that is here. You guys can take a look, but it's, again, we're able to kind of really help you guys get into the right direction. For the EB2 NIW green card, I see that there's a few qualification criteria that I want to walk you through. If you qualify for the EB2 NIW, sorry, one second, then these are the ways that you would qualify for it, whether it's through substantial merit and national importance, to being well positioned to advance the work, and to benefit the United States that outweighs the need for a labor certification. This might not be as helpful for individuals who are born in categories that are very heavily backlogged, but maybe your EB-2 priority date is already current, but it was through a prior employer. So that's something to definitely consider as well. And here's also another sample profile that we've worked on previously. So for country-specific visas, E3s and TNs, right, this is something that I really want to focus on as well. If you're here in the United States and you're from Australia or you're from Canada and Mexico, you should be prepared to maybe swap visas, even though you might have just swapped onto the H-1B. And a lot of it has to do with just knowing that you have that alternative. E3s are substantially similar to H-1Bs. They are in specialty occupations. They are kind of using the same mechanisms, but they're protected by a treaty that is between the United States and Australia. It is renewable, it is accessible, it can be renewed indefinitely in 2-year increments, and it is very similar in requirements to a general H-1B. For TN visas, it's for individuals who are Canadian and Mexican. They are available under the NAFTA agreements. They are designated for certain professional occupations. For those who are in STEM, the most friendly options are for computer systems analysts, engineers, mathematicians, biologists, chemists, and statisticians. And they're usually relatively fast to process, especially for Canadian nationals who can apply at the border. So what does this mean for all of you in terms of like what the next steps are? The reality is that there is going to be a rulemaking process under the Administrative Procedure Act that is still required for prevailing wages. My perspective when it comes to taking a look at this is that wages could be increasing for a lot of employers because when we're pushing the prevailing wages up, that means level 1, level 2, level 3, level 4, all of that changes as well. There could also be, and it seems to be the case when we're looking at the guidances, an impact on the fiscal year 2027 H-1B lottery. That would be the lottery in March of 2026. So for many of you who are approaching graduation, or many of you who are looking at OPT or STEM OPT transitioning into the H-1B, you need to be prepared with alternatives just in case you can't find an employer that is willing to pay this particular cost. However, there is a lot of expectation within our field for legal challenges and advocacy responses. I think many of you have seen, whether it's on LinkedIn, on Facebook, and other social media posts, that there are litigation firms that are collecting the right signatures and individuals to seek a class action lawsuit that could potentially serve as the backings for a temporary restraining order to temporarily delay the start of this process. The other thing is that I really emphasize to many of you who are on the H-1B, or maybe if any of you are employers who sponsor H-1Bs, that you need to be consulting with immigration attorneys, whether it's myself, other firms out there, or your immigration partners. The reality is that the only way to truly know how you are impacted requires us to take a look at your case materials. When did you file? Did you leave the country? Do you have a valid stamp? What is the latest and greatest? I think one thing that has been proven from this conversation alone is that everything is changing every 10 to 20 minutes to an hour to 2 hours. So it's so important to keep in touch with the right professionals who really know how to advise you. So we have a Q&A section right here. I'm more than happy to answer as many questions as I can. I'm going to kind of scroll up and continue the conversation. So I see here the first question that's up there is, will the 100K have to be paid for a case of a concurrent H-1B filing by a second employer after the 21st of September? By when do you expect to get clarity on this as well as transfer? So when I'm taking a look at this, a concurrent H-1B can be treated technically as a new petition, right? And the cutoff date that USCIS that established is that they're saying that any petitions that are filed after the 21st, if it's not considered a renewal, counts as something that could have the fee. But again, that's where we're at, is what is the definition of a renewal? Technically, concurrent employment is you seeking an application that could be a longer period of time than your previous approved H-1B. So what does that even mean? What do we do in that context? I don't think we have clarity at the moment for me to even tell you if it's going to apply, but conservatively, it seems like it would. In terms of when are we going to get more information, I really think every single day we're going to be getting more information, and we're going to need to push out a lot more content. And I hope that you guys follow us on our social media, because we really try to be as quick as possible with sharing a lot of that insight. The next question I see is, what kind of lawsuit are you expecting to be filed against this executive order? Is there any way to gain visibility on what's happening on the lawsuit front in real time? LinkedIn seems to be the best way for you guys to get that insights, or Twitter/X, right? Because there's a lot of lawyers that are talking about this and also soliciting individuals who are maybe affected by this. But all I can say is that there's a lot of rumblings, there's a lot of grounds that are related to a potential lawsuit. The question of whether or not $100,000 is considered reasonable or not, and whether or not the government needed to go through a rulemaking process per the APA for this is definitely an open question, right? If a person applies for an H-1B extension after September 2025 from USA, does the 100K fee serve as being applicable? That's the question. What kind of extension, right? The traditional notion of an H-1B renewal is that I'm renewing my H-1B with the same employer. I think that's probably the safest bet for individuals who may not have this 100K fee be applicable. But what if it's a change of employer with extension, right? When you change employers, you can ask for more time. Isn't that also technically a renewal? And we don't have that clarity. But the conservative advice that I've been giving to a lot of corporate clients is to assume the only individuals right now who are seeking renewals after the September 21st countdown are the individuals who are sticking with the same employer. No one is answering one major question. Does F1 students in USA, either in OPT or CPT, if they apply for the next H-1B lottery in March 2026, will the 100K apply to those graduates? It seems so. If you take a look at the press secretary's explanations and also the FAQs that were released by USCIS on this H-1B, they both reference the lottery, the upcoming lottery. And those are truly new petitions, right? They're new employment petitions under the H-1B. So I do think this 100K rule will apply for those graduates. Could you clarify on how the proclamation could impact physicians transitioning from the J1 to the H-1B under waiver programs such as HHS and underserved area, kind of like the Conrad 30? Listen, the proclamation and all of the guidances so far don't distinguish between the types of H-1Bs. But what I will say is that the government did establish a carve out for the Secretary of Homeland Security to determine exemptions for this particular fee. There was a report by Reuters that mentioned that there could be exemptions for physicians. So I would think that potentially you would fall under those exemptions, but there's no specific guidance right now that has been issued when it comes to exemptions. Next question that I see is, are transfers considered new petitions? I think they can be. But again, it goes down to the definition of what the government is saying is considered an H-1B renewal. Terminology is everything, guys, especially for practitioners. I think many of you who are on H-1B know change of status, extensions of status, change of employer. These are all different boxes to mark. So which boxes, when they get marked, trigger these things and which boxes do not? We don't have that insight and or information. What if the government is releasing a new form related to this? What happens if a person finished 6 years on the H-1B and there's an EB-2 green card in process in the perm phase? Now that they have to leave the USA, and let's say there's an I-140 is approved 2 years later, will they have to file a new petition for H-1B, or will it be called a renewal petition? That is a good question. It could be considered new employment, but it's technically like getting more time on your H-1B. So that's why I keep on saying, what is the definition of a renewal? What do they mean by that? Right? Because there's no box on the I-129 that says H-1B renewal. Will the H-1B cap exempt petition also have a $100,000 fee? Or maybe the government will make an exception for the H-1B cap exemption in the near future. They could, but as of right now, as the proclamation is written, there is no exemption. It's just that they could establish an exemption. Let's see here. Hi, I would like to know if H-1B job transfers are also affected by this, and how will this be affecting H's and H-4 EADs, right? So when it comes to H-1B job transfers, that's the thing. I know I keep on repeating myself, but I want many of you to understand the confusion that's out there, which is, what is the definition of a renewal? Right? Because the statement by the press secretary makes it seem like, these job transfers don't require this $100,000 fee because you're technically an existing H-1B holder. But the guidance from USCIS that was published along with the FAQ doesn't insinuate the same thing, right? And the defense of like it only applying for next year's lottery is really only established to some degree by USCIS, but it's not congruent with what was said by the press secretary. You have travel planned for the 27th of September going for stamping too. Is this a suggestion still not to travel? I just would do I would avoid any non-essential travel. I just would. It's too tumultuous right now. There's so many statements, there's so many interpretations. Like, I know you've already been approved, but what does that even mean if the guidance is changing every 20 minutes? Do not be the guinea pig to test these things out, right? Because in you being the guinea pig, if you end up being somebody that is stuck outside of the country, how quickly can you get brought back in is another question. Is it applicable to the healthcare center as well? Healthcare sector as well, especially for physical therapists? Again, it's unclear. There are ways for the government to provide exemptions as stated on the proclamation. And there was a publication from Reuters that stated that there could be exemptions for physicians, but I don't know if that extends to physical therapists at this time. If anything, we don't even know if that exemption is actually true because we haven't really seen published policy on it from the Secretary of Homeland Security. So next question that I see is, if a person has a stamping appointment for an H-1B extension upcoming, will they have to pay a $100K upon re-entry? I think it depends on the basis of that extension. If it was an extension that was filed for and approved prior to your entry into the United States, right, and prior to that September 21st, 12:01 a.m. EDT deadline, then there should be a way for you to come back without paying this $100K. But again, do you want to be the guinea pig? I don't really have the mechanisms in place to see whether or not that $100K could apply to you or if you would need to pay it. And even if you wanted to pay it, how do you pay it, right? There's still so many open-ended questions, right? And that's what I think this individual was emphasizing. I see a statement here. The USCIS memo and Press Secretary Caroline's tweet has a huge difference, 100%. They're very different connotations. Like how is it one side is saying that it will only start applying once the lottery occurs for next year, but another side is saying that yes, it's going to apply starting September 21st at 12:01 a.m. EDT, which has already passed, right? I see here from a woman named Angelina, Howard Lutnick mentioned in the initial press conference that the green card categories will be scrapped in order to give way to the gold card. Any indication what would be happening to EB1? No, I do not see an indication. And actually the language that's used in the proclamation focuses a lot on EB2 NIW language, right? They use terms like exceptional business ability and national interest. So the way that I take from that is it maybe changing what EB2s look like, or is it taking from the employment-based categories? I don't know if they're going to be completely replacing them, but I feel like that would create a challenge, let's say. I think that there would be a legal challenge to that impact or that scale of impact. Is healthcare really exempted? We don't have any official policy on that. I don't have an official publication that says that healthcare is exempted. There is a Reuters report that said that there could be physicians who are exempted from this $100,000 fee, but it is unclear at this time. Does the $100K fee apply for the STEM, non-STEM OPT transfer to H-1B for the 2026 lottery? If you mean by the 2026 lottery, next year's March 2026 lottery, it seems to be the case. Can you say anybody on a student visa who is about to apply for the H-1B next 2026 of February, March window would just go through the regular normal process for like all these years and not be subjected to new $100K policy? Not according to the statements from USCIS and to the statements from the press secretary on this regard. See here, a lot of these questions are repeated. What is a good way to contact USCIS to seek clarity on this topic? There is no good way at the moment. Trust me, if I knew who I could call at USCIS at this moment to get some clarity, not only would they shut up that hotline immediately because of all of the requests that are coming in, but the reality is that there isn't really a good way. We just will need to wait and find out from when there's going to be new guidances that are issued. Let's see here. It goes, I think the president only has executive power for travel bans, so this really should apply to first-time H-1B petitions from abroad and should not apply to COS cases from within the U.S. But it doesn't stop the president from issuing a directive to have USCIS add those things in, or other agencies, right? Is it that they might have needed to go through a rulemaking process to do so? Maybe, right? But I don't think we should take this as it's never going to happen. It's very possible that a lot of these things will change, and the final version of what actually ends up being implemented could look very different. But conservatively speaking, there are mechanisms that could be put into place to increase those fees or those costs that are associated with the H-1B, right? What about possible lawsuits? Touching upon that, there's a lot of conversation about a potential class action lawsuit in order to sue the government and create a scenario for a temporary restraining order against the government to prevent them from putting this into play until litigation is completed. F1 students might leave overnight to avoid overspending. That's why I think they are keeping this ambiguous for the past few days. Maybe, but I don't think F1 students should be leaving because of this, because the regulations focus 100%, or not the regulations, but the directives are 100% focused on the H-1B. There isn't really a conversation topic. It's not like the proclamation says that F1s are being banned and that you need to leave. It's just that the main option of being able to stay once you graduate, the H-1B, may be a little bit harder to acquire in terms of cost. But that doesn't mean that you should leave, and you really should be exploring what your other alternatives are. Are doctors currently on J1 going for H-1B cap exam next year? Are they impacted? The way that the proclamation is written and the way and everything is written is that, yes, it could be impacted. However, as I mentioned, there is a Reuters publication that stated there could be some exemptions for physicians, but again, not fully fleshed out just yet. H4 to H-1B possibility, is that subject to the 100K fee? Potentially. Is it considered a new petition? Maybe. Right? The only reason why I keep on saying maybe is because the government's definition of a renewal is not clear, right? So what is exempted or what is not exempted is also not clear. Does this affect cap exempt filings at the current state of things right now? Yes. So location doesn't matter, whether the new petition is filed from the USA or the outside. That's what the guidances are saying, is that it doesn't distinguish between the two. It doesn't. But the thing is that we don't know because the actual implementation of the policy is not clear yet. Does working in medical companies count as healthcare, and is it exempt for this fee? I want to make it clear there is no official policy that says that healthcare is exempted, right? I just will tell you that Reuters did publish a publication that said that they've heard that there is going to be an exemption for physicians, but I don't think it's the healthcare sector as a whole. Why is it applied to someone who has been approved but doesn't have a visa yet? It's not that I'm not really entirely sure, but what I can tell you is that the way that the government wrote the guidances creates a lot of or statements, right? You did 1, 2, or 3. Now, ors can be good because then we can say, well, you have an approved visa stamp, but you needed to file a brand new petition, right? Does that mean you need to pay the 100K, yes or no? It's unclear. So I think what I really want to emphasize to you who asked me this question, that a lot of it is unclear, right? So actually, Samar actually made a really good point, which is that for the H-1B, Bloomberg is saying that doctors, nurses, care workers may be spared from the $100,000 fee, but there is no official confirmation from a government body, and that's super important. Now, the next thing is, does this impact any person switching from a 485 EAD and using the I-131 travel card from the H-1B? So I think what you mean is that if you're doing an adjustment of status, if you have an advanced parole document, you should be able to travel right now based on that parole document, right? I see a very negative kind of question here, so I'm going to make sure that you put this person on timeout. We're not here to make ad hominem attacks, guys, and we're not here to make a political opinion. I'm really genuinely just here to answer as many questions as possible. I filed my petition on June 30th. Initial change of status. When should I expect the decision? So even for some of my clients who filed all around June, we're still waiting on pending decisions for regular processing. I am expecting an answer on or about in October, but you shall see. I am currently on a J1 research visa working at a university, but I will need to switch to an H-1B next year, working at the same H-1B cap exempt position. Does that 100K apply? I believe so. It's considered new employment. It's a change of status, right? So I will say that as of it's written right now, there would be an impact. So you should be considered other alternative options. I see here an H-1B petition applied under consular processing 2 months ago. Cap exempt employer. I live in Canada and travel every day to work on F1 OPT. Right? So when it comes to your H-1B petition filed under consular processing, right? If you applied for it 2 months ago, then the proclamation should not apply to you because it says if you're pending, it doesn't apply to you. So thank you for the kind words, everyone. I'm trying my best to answer as many questions as I can. I see here, AJ, that you believe that the proclamation will also be challenged in court. Only Congress has the power to change visa immigration-related laws. Congress there are a lot of things that require congressional action, but it is true that the executive authority has the ability to give directives, right? They can tell somebody to do something, and they can also provide the means for, let's say it's like the travel bans, right? Like Trump does have the ability to restrict people's entry. So under the COVID pandemic or under the at least during Trump 1.0, there was the ability to provide these bans almost effective immediately. So I wouldn't say that anything immigration related needs to go to Congress. That is not necessarily the case here, right? When do you think the administration will release more details? That is also still unclear at the moment. I wish that I had more guidance on that point, but I do think that there's a lot of pressure right now on the administration to provide greater guidance, because the more that these questions come about and the more public it is, the more that I can see companies, things on the back end really pushing them to say, you need to clear this up because this is going to be a big expense. Think about it this way. Amazon has 10,000 LCAs, guys. Can you imagine if this was a one-time fee for every single H-1B petition ever? If we took the proclamation as is with no guidances, how many $100,000 fees are going to be paid? About $1 billion worth of these $100,000 fees. So these clarifications are going to be made over time, whether it's today, tomorrow, or over the week, or in the next month. I am Mexican and on an H-1B. Can I switch to the TN if needed? I already had a TN in the past. Yes, you can. You can switch back to the TN, and I think it's something that should be considered, especially as the situation evolves. I read somewhere that it applies to the lottery in 2026, and that would gauge the situation moving forward. Is that true? Yeah, the government made it clear that it is going to apply for the lottery. Both USCIS confirmed that along with the press secretary. If it is effective only as an entry ban, then as long as the petitions without 100K fee remain in the US, they don't need to worry. That's also one area of lack of clarity. You're right that the ban is on the restriction on entry. Like, that is what the proclamation says. But that is not necessarily what USCIS said, to be clear. And take a look at the H-1B FAQs, and that's why a lot of attorneys are like, I'm still waiting for more insights. I just want to make clear in these situations, does it apply? Does it not apply? Right? Those are some real legitimate questions. So we're nearing the end of our time here for the webinar. I think we set aside 45 minutes for this, and I'm a little bit over time. I really know that many of you still have so many questions, and I'm trying so hard to answer every single one of them. The reality is that the best way that you can reach out to us is to follow us on Instagram and DM us there. Use our email, which is at help@manifestlaw.com, and our website, which is manifestlaw.com. I know that at the end of the day, this is a very distressing time, but the best thing you can do is get the most up-to-date advice and be in touch with the professionals who can help you. Really consider the alternatives that I've talked about. Even if they seem far away, I would rather you start preparing for them and start building towards them so that you can be put in the best position. Now it says here, I'm going to take on this last point. Correct me if I'm wrong, but according to the ban on the restriction on entry, even if there's a change of status from F1 OPT to H-1B, you could be issued an I-797, which could be to force reentry in the fee. Potentially, but that's, again, that lack of clarity at the moment, which is why I am taking the most conservative position at this time, guys. The most conservative position to be in is to make sure that you have those alternative plans to stay in the United States where possible and to find maybe kind of the best and greatest in guidance as these things evolve every single day. I see your question, what is the minimum percentage of profile readiness below which you don't accept cases for EB-1A filing, etc.? Well, I will tell you that we have a lot of great programs, but a lot of my mark is what I call a 2.5er or a 2er, which is that I would like to see a level of credibility already, whether you're already working within the industry or you have at least 2 criteria that are met before we can have a really good conversation on how we can help you get into those 3rd or 4th criterias. But it really depends. And I do encourage you to send us an email with your resume and we'll send you a questionnaire to see how we can help you where possible. Okay. But thank you so much, guys, for your time. I know that, we're wrapping up to a close. I really appreciate it. I also appreciate that many of you are very actively involved in answering or asking these questions. I do hope that today's session was as informative as it can get. I tried my best to answer as many of your guys' questions, but I appreciate your guys' time. We will have this recording up somewhere for you guys to view. So I really hope that you're able to share it, whether it's with yourself to review or share it with your family and friends and any of those colleagues that are impacted. So thank you so much, guys, for being here. And I do appreciate the thanks that I'm getting on the chat. If you guys really appreciated our live here today, don't hesitate to send a review our way via Google. We do appreciate that because we really try to provide a lot of great insights and be as transparent with our information. But I think as this week goes on, we'll be continuing with webinars and more helpful guidance as we get more of that guidance. Okay. Thank you, everyone. Take care. Thank you.